Very good afternoon to all my dearest student friends. Indeed, it gives me a great deal of pleasure in making a deliberation on intellectual property rights. So, today's deliberation will be on intellectual property rights, and after hearing the deliberation, the students will be able to understand the meaning of intellectual property. They'll be able to explain the need for protecting intellectual property. So there are different types of intellectual property one can have. So what I mean to say that after deliberation, one will be able to not only understand the meaning but also the necessity of intellectual property, why it is needed, and what are the different types of intellectual property are there. So the deliberation will have a structure like I'll give you the introduction of and what is all about intellectual property and what is the rationale behind it, what is the justification for protecting intellectual property, and what are the different types of intellectual property one can have, starting from the patents, through copyrights, through trademark, through graphical indications, including your industrial designs, plant variety protections, apart from protection of layout designs of integrated circuits. Of course, one cannot leave the trade secrets. So today, when we talk about contemporary world, we live in a world which is surrounded by diverse types of intellectual property rights. So normally as a student, you must be reading books, listening songs, and going Inox, PVR for watching movies. And the diverse applications as a student you use on your phone, they are just some of the, I would say, many kinds of works which might be or which might have been, I would say, protected under different kinds of intellectual property protection. So that is why I must thank to the frequent appearances of the term that is intellectual property in the mainstream media as well as every day in our conversation. So when we are talking of intellectual property, obviously it is really relating to the creation of the mind. So one of the first things to remember is that intellectual property is not a single body of law, or you can say is not a homogeneous body of law, but rather it is a term which is making an attempt to collectively describe the number of areas, like the number of areas of law, rather to be more specific, with some kind of distinctive characteristics. So when we are talking of intellectual property, there is no universally accepted definition of intellectual property. And of course, when I say so, this is quite surprising, is not it? As it is nearly impossible, rather, to find one definition that can very comprehensively cover all the subject matters that are currently considered in the intellectual property. So, when we are talking of intellectual property refers to creation of the mind. Creation of mind, such as inventions, such as literary works, such as artistic works, such as your design, such as the symbols, the names, the images which are used in commerce. So, intellectual property refers to a loose cluster of, I would say, legal doctrines that regulate the uses of different sorts of ideas and insignia. However, if the term intellectual property refers to loose cluster of legal doctrine, then it becomes pertinent to ask when we can call something as intellectual property. So that is why when we are using the word term intellectual, indicates the character, the character of some, you can say, some of the material the area of law protects. When I say law, some area that law is going to protect, that is the products of human mind, products of human intellect. And the term property indicates the form of regulation. And when I say forms of regulation, that means the granting of exclusive rights which operate in a manner, the manner which is similar to your property rights over tangibles. And as a matter of fact, different countries they protect their diverse creations of the mind under different branches of law, and that is why when we are using this, so we have also patent law, we have copyright law, we have trademarks, we have design law. So together, they are often referred to as intellectual property laws, though it needs to be kept in mind one thing, that is becoming increasingly difficult to find a common theoretical justification, as I told you earlier, for all sorts of branches of law. So going for the justification, and the justification for protecting the intellectual property, while there are different theoretical rationale one can have in the context for affording the legal protections to different types of, you can say, intellectual property. The most widely used one is the incentive theory. That means that is known as, better known as your welfare theory. So according to the proponents of this theory, most information products that we are talking of today, like starting from the book or the music that you hear, they have got two characteristics of public goods. So when I say two characteristics of the public goods, obviously the first characteristic is a non-rivalrous, non-rivalrous character in consumption. We say that the good has non-rivalrous character in consumption when more than one person is able to use the good, and that too, when they're using simultaneously without affecting the possibilities of others. So in the process, the product is stored on the cloud, which could be read by more than one persons, and each person would be able to read the book, and that too without diminishing the possibilities of enjoyment of reading of that book by another person. So on the other hand, when we look at the book, if the book is in the physical form or the book is in the hard copy, then only one person might be able to use, and the copy also at one point of time, at a time. So most information products have non-rivalrous character in consumption. The second characteristic is non-excludability. When I say non-excludability, that means this is relatively hard to exclude people from the consumption of information goods. So this is, in fact, a particularly important challenge for us, as many information goods also have a strong positive externalities. So economists, they always argue that because of these public goods characteristics, inventors, or the who are the inventors, they are the creators, will not have the incentive to create information products, and there will ultimately be underproduction of information goods. So to address this issue of underproduction, economists, they suggested that there should be at least some legal protection against copying. So the legal protection suitable for different information products would have to be fine-tuned both in terms of, I would say, duration of protection and the scope of protection. So keeping in mind the both, requirement, both the requirements of protecting the incentives for production of such goods as well as broader interest of the society in getting access to such products. Most laws that come under the broader umbrella of intellectual property laws, particularly your patents, your copyrights, which can be seen attempting to seek this fundamental balance through your diverse measures, such as limited term protection and exceptions to infringement. So, in this context, your trademark is also another type. There are two commonly cited economic arguments. Firstly, when we are talking of trademarks, it can reduce consumer search cost, and in the absence of trademark, consumers may have to spend substantial amount of time. So consumer have to spend substantial amount of time, efforts also to identify the product which they wish to consume. Secondly, in the absence of the trademark protection, there may not be much incentives for the producers to maintain the or to improve the quality of their products or to maintain or to improve the quality of their services. So, in other words, your trademarks have a self-enforcing characteristics, and when it comes to quality improvement. Now, coming to the types of intellectual property, as I told you earlier, intellectual property laws is not a homogeneous body of law. So, as a matter of fact, when we are talking of it is not a homogeneous body of law. Obviously, the aspect has to be seen rather as a collection of distinct but rather legal doctrine covering your diverse subject matters. So, this deliberation, which I am going to make right now on the types of intellectual property, the basic aspects of some of the, I would say, major types of intellectual property. To start with, patents. When we are talking of patents, obviously, when we are talking of the patents, it is a limited term monopoly, which is granted for an invention, that too in return for a disclosure of the invention to the public. So, since we are Indians, so in India, the patents are very much governed by the Patents Act 1970. And registration, but registration of your patent is mandatory for getting your patent protection. So, in fact, many a times patents are granted after a rigorous examination process. So, which involves different types of steps. A patent, there will be an application which is known as patent application, and the application will contain the title of the invention. You have to give the description of the invention, and that too, the description should be given in a manner in which a person skilled in the art and could work or could reproduce or could when it is good to reproduce that invention, or you can have a set of claims that define the legal boundaries of the inventions. So that is why the term invention protection in India is 20 years from the date of filing of the application. And during the term of protection, obviously the patents ensure one thing, that the concerned invention cannot be made, cannot be sold. The concerned invention cannot be also disturbed or used without taking the consent of the patent owner. And once the term of protection is over, obviously now the patent will enter into the public, and a patentable invention can be in relating to a product, can be relating to a process. So to be considered as an invention, obviously one has to look for one thing. For the purpose of patent law, there are three general requirements. One is the novelty, another requirement is your inventive step, and the third requirement is your industrial applications. So it is also important to ensure one thing, that the concerned product or the concerned process is not specifically excluded subject matter under the relevant patent statute. Because in India, Section 3 of the Patents Act 1970 has already provided a long list of exclusions from the patent protection. So the exclusions are very much based on the diverse public policy reasons. Similarly, the Section 4 of the Patents Act also provides that the inventions relating to your atomic energy, which fall within the subsection 1 of the Section 20 of the Atomic Energy Act 1962, are not also patentable. So now coming back to the three general requirements, that is novelty and your inventive steps and your industrial applications. To start with the novelty, obviously it has been defined as per the Patents Act 1970 that any invention has to be new invention. So how do you know that it is new? So new invention means any invention or any technology which has not been anticipated by the publication of in any document or used in any country or elsewhere in the world before the date of filing the patent application, with a complete set of specification. That means the subject matter has not fallen in public domain and it does not form even part of the state of the art. So in other words, you may put it like this, that the publication of the details of the invention in any document or the use of the invention in any part of the globe can negate novelty, and the patent noted that novelty has to be determined, no doubt about it, in the light of the single prior and when I'm talking of single prior art reference is not permitted in novelty analysis, because in other words, compiling different documents, then if you are comparing it with some kind of technological features, inventions, either it is explicitly or implicitly. So there also need to be complete match between all the technological features as very much disclosed in the application and the cited single prior art reference. So however, statute has also provided that the certain, in fact, the specification exceptions one can have to anticipations. Now, the second requirement, that is your inventive step. That is the inventive step. When I say that is the toughest, I would say, requirement to meet among the three essential factors of patentability. So in India, the Patents Act 1970 defines your inventive step as a feature of an invention that involves some kind of technical advance, as in fact compared to the existing knowledge, or having some kind of economic significance, and both that makes invention non-obvious to a person skilled in the art. So inventive step is always done from the hypothetical construct of a person skilled. So the statute, in fact, hasn't provided any kind of definition for the terms technical advancement or the economic significance. Similarly, the third requirement for your patentability, that is your industrial applications, the utility part. So obviously, when we are talking of industrial applications, it is capable of your industrial applications in relation to an invention, means that the invention which you have made is very much capable of being made or used in an industry. So it needs to be reminded one thing, that even if an application made can show that the application meets all these three requirements of the patentability, And to be successful in a patent applications, it is also important to ensure one thing, that the subject matter of the invention is not specifically excluded subject matter under the Indian patent law. Now coming to the third one, that is your copyright. Uh, Copyright, in fact, protects creative world. It protects creative work. It protects artistic work. So the diverse kind of works that can be protected by the copyright include books, include your music, include your movies or paintings, sculptures, computer software. So in India, the copyright is very much governed by the Copyright Act 1957. So copyright provides a bundle of rights for the creators, and the types of right provided that would vary with the subject matter. For example, the bundle of rights provided on the Indian copyright law for the creator of literary works, they are the right to reproduce work in any material from form, including the storing of it in any medium by electronic means, right to issue copies of the work to the public, not being copies already in circulation, right to perform the work in public or communicate it to the public, right to make any kind of cinematograph films, also sound recording in respect of the work, right to make or any translation of the work, right to make any kind of adaptation of the work, right to do all this which I told you in relation to translation, in relation to adaptation of the work. On the other hand, if you are talking of cinematograph films, for that the bundle of rights provided right to make some kind of copy of the film, that means image forming part thereof, or the storing it in any medium. You have also right to sell or give on economical rental basis, right to also communicate the film to the public. So these are all, I would say, depending on the subject matter and the type of rights or the extent of rights which are granted under copyright law. To whom it is granted to the creators, that would vary substantially. So in this case, in India, for a very long time, the courts followed so-called suite of the bro approach. And what is that suite of the bro approach, which focused primarily on the labor put by the creators, but in the landmark decision of the Supreme Court, in the case of Eastern Book, explicitly and adopted that the skill and the judgment test which was laid down in the Canadian Supreme Court decisions also. So as compared to your patents, the duration protection is longer in case of copyright. The term of the copyright protection varies with the subject matter and the duration for different subject matters which are under copyright law, and they are dealt with by the Copyright Act 1957. So the copyright protection for literary, dramatic, or if you are talking of also music or any kind of artistic work other than your photographs published within the lifetime of the author, and that will continue until 60 years from the beginning of the calendar year next following the year in which the author dies. So the term of the protection of the photographs under the copyright law subsists until 60 years from the beginning of the calendar, and the next following the year in which the photograph is published. Similarly, if you are talking of the cinematograph films, the term of protection is 60 years from the beginning of the calendar year, and this is also following the year in which the film is published. That means the next following the year the film is published. So the term of protection provided for sound recording is 60 years from the beginning of the calendar year next following the year in which the sound recording is published. So it is very important to note the moral rights protection in India extend beyond the term also of the copyright protection. So that is why we have collective management of rights is very common in case of copyright, as it is difficult, in fact, to monitor rights, to enforce right at an individual level. So for this purpose, normally we look at that the rights of the author must be secured. And some of the famous copyright societies include your Indian Performing Rights Society. The society deals with the rights of the author, the rights of the composer, rights of the publishers of music. Now, coming to the trademarks, the trademark, in fact, is another important type of intellectual property rights. In general, trademark refers to a word, it refers to a symbol or any other significant that can distinguish the goods, that can distinguish the services produced by one firm from the goods or services of another firm, from one firm to another firm. In India, if we are talking of the trademark, they are all governed by Trademark Act 1999. So the Trademark Act 1999 defines trademark as a mark, or the mark which is capable of being represented graphically and which is very much capable of distinguishing the goods or distinguishing the services of one person from those of others, and they may include the shape of the goods, their packaging, combination of colors, everything. So, what I mean to say that in all these cases, what is important, that is your geographical indications. Because geographical indications broadly refers to signs used to products that have specific geographical origin and the quality or the reputation that you are talking of, the reputation of the product that is attributable to that geographical origin. So we have got TRIPS agreement has mandated the protection, no doubt about it, of the geographical indication. The TRIPS agreement, so India has also drafted as a sui generis law for protecting geographical indications. So the title of the legislation, when we are talking of, that is the geographical indication of goods, in fact, Registration and Protection Act 1999. But however, even before what we have seen, before the enactment of this legislature, passing of action has been acting as a powerful remedy, no doubt about it, in India against the unauthorized, rather to be more specific, unauthorized use of any kind of geographical indications. So it is still very useful remedy in case of authorized users of unauthorized geographical indications in India, because some of the producers have also been using certification mark and collective mark. These marks only to protect your geographical indications. For example, the word Darjeeling and its logo, they were all registered as certificate mark in India by the Tea Board of India. So the Act, when we are talking of geographical indication, the Act indicates the geographical indication is a relation to goods, is a relation to means, and indication which identifies, in fact, such goods like agricultural goods, natural goods, manufactured good as originating or manufactured in the territory of the country or in a region or locality in that territory, where a given quality, where a given, in fact, the reputation that we are more concerned about, the other characteristics of such goods is externally attributable to the geographical origins, and is the, in case of where such goods are manufactured goods, then in that case, one of the activities of either the production or the process or the preparation of the goods concern takes place in such territory, in such region, locality as the case may be from time to time. And that is why we are more concerned about to that the term geographical indication protection. In fact, one thing we look at the application has to be filed in the prescribed form before the geographical indications registry, and as geographical indication is a collective right, so it is important to note that unlike your trademark applications or like your trademark applications, individuals in fact cannot file, cannot get geographical indications. So that is why it has to be filed by the association of persons or the association of producers or any organization authority if they are representing the interest of the producers, the producers, and in fact, when they are representing the interest of the producers, and they have to take into account that the producer's interest is taken care of the so far as the concerned goods are concerned, and apart from that, the application also required to file an affidavit very clearly indicating how they represent their interest. So now coming to the industrial design is another type of industrial intellectual property rights, which has garnered considerable prominence in the context of high profile litigations such as Apple versus your Samsung, because in the Apple versus Samsung litigation saga, one of the questions that had to be addressed by the court was whether Apple was entitled to prevent competitors from using the rectangular shape with rounded corners and the rounded home button at the bottom of the screen on their phones. So in the United States, what happened that the jury initially awarded Apple 1,049 dollar, that is the $1 billion in damage way back in 2012 on different grounds, including infringement of rights over the choice over the those designs. Even though the intellectual property scholars they disagree on the justifiability of the outcome of Apple versus Samsung, most scholars would agree that the litigation has raised awareness among the firms. The litigation has raised awareness among the firms on the economic industrial design, or that is a type of intellectual property rights that protects your aesthetic feature, that protects the ornamental features of an article. So the registration so made confers copyright in the design for the duration of the registration, and the registered owner will have the exclusive right. In fact, when I say exclusive right, that is the right to apply that design to the article in the class for which it is all designed. Similarly, the duration of the copyright protection in the design shall initially be for a period of 10 years from the date of registrations, but the protection may be extended for another, I would say, 5 years, provided the application files an application in the prescribed form, and that too before the entry of the initial 10 years. So there are also plant variety protections under types of protections. And in the plant variety protection, given the enormous demands from the diverse stakeholders for protecting new plants varieties, it would be appropriate to mention that different countries have taken different steps for protecting new plant varieties, because in some countries they are protected under the plant law, and in some other country they are all protected under the sui generis law. So India is a signatory to the TRIPS agreement, to which India is a signatory, And as a matter of fact, these are all mandated that the member state, what they should do, they shall provide for the protection of the plant varieties, and either by patents or by the you can say effective sue generis system, or by any kind of combination thereof. So, in other words, you can put it like this, that when you are talking of this, obviously you have variety as plant grouping, except you can say microgroup organism within a single botanical taxon of the lowest known rank. So the different categories in which a plant variety can be registered to in India, new variety, or it is a extant variety, or it is essentially derived variety. So then only you, as per statute, the variety shall be deemed as novel. So whatever different categories in which the plant variety can be registered in India, they are new variety. So extant variety and essential derived variety, these are all in, you can say new variety, which can be registered under the Act if the variety is going to meet the requirements of the novelty, requirement of the distinctiveness, equality, variety of your, you can say, uh, the third one, which is more important, that is the uniformity along with your stability. So, in all these cases, what we have seen that if it is essentially derived variety in respect of initial variety, obviously that should be said to be essential because it is all derived from such initial variety. Though predominantly it is all derived by when we are talking of the initial variety, not the latter variety. So, having said that, the protection in respect of layout design, and that too, the layout design of some kind of integrated circuits, because in India, when we are talking of this uh, Layout Design Act 2000, obviously, the statute was enacted in furtherance to the obligation. So in India, under the TRIPS agreement, the statute is going to define that the semiconductor indicated circuits. So a product having transistors and other, you can say, circulatory elements which are very much inseparably formed on the semiconductor himself, or some kind of insulating material you can go for, or inside the semiconductor. So material and the design to perform both. There are electronics circuitry functions. So in that case, the layout design is defined as the layout transistors and the other circuitry element that includes your lead, wires connecting, in fact, such elements which are expressed as any manner in a, you can say, semiconductor integrated circuits. So to be more predictable, it is important to say that to be predictable, layout design has to be original and has not commercially exploited in India, or the invention uh, will make some kind of, you can say, service, as well as to be protectable. A layout design has to be original, not being commercially plotted in India. Or you may say that in a convention country, inherently it is distinctive and distinguishable from the other registered layout designs. So, in all these cases, trade secret is also more important, because when we are talking about trade secret, we have to see one thing, The trade secret are intellectual property rights over confidential information. Some of the most prominent examples of the information protected as trade secret, they include your Coke recipe and the recipe behind Kentucky Fried Chicken, and other information like customer is listing can also qualify for trade secret protection. But however, I must clarify one thing, that to qualify for because to qualify for trade secret protection, obviously, we have to see that not all information would qualify to attend some kind of trade secret protection. Because to qualify for trade secret protection, there are primarily three requirements. Firstly, the confidential nature of the information makes the information a commercially viable. Because the lastly, the holder of the information has taken comfortable, or you can say reasonable steps to keep the information secret. So Art 39 of the TRIPS agreement has mandated the protection of trade secret by the member states. So the natural and the legal persons shall have the possibility of preventing information lawfully within their control from being disclosed to or not being acquired by the officer or used by others. Without these are all without their consent in a manner contrary to your you can say honest commercial practices, so long as information is concerned. So this trade secret has commercial value. It has got commercial benefits also, and it has been, I would say, it has been the subject to reasonable to demonstrate some kind of reasonable steps. Next, maybe under the circumstances by the person lawfully in control of the information to keep it secret. But however, the TRIPS agreement, in fact, has provided one thing, that sufficient flexibility to the member states in determining the paths through which trade secret protection may be given. So while some countries have enacted specific laws for the protection of the trade secrets, so our country, like countries like you can say India, protected trade secrets. Though the principle, though the principle that we are more concerned about has to be seen, and specific laws for the protection of the trade secret. Countries like India protect trade secret through principles of equity, and common law remedies is being applied for breach of confidence. So, like most of the other types of rights, your trade secret also can also be assigned to license. So that is how, as one may notice, one thing, that when we are talking of these things, try to recapitulate one thing, as one of many will notice one thing for the discussion in this unit, that different kinds of IP, they play a major role in determining individual access to the knowledge, individual access to the resources. So, in all cases, what is important, that we have to see that how best things can be taken into considerations. So that is the case why we are more concerned about the intellectual property, because in most of the cases, what we have noticed, that the invention you have gone for but somebody is using without taking, then that will be kind of infringement, violation. Because we have to be sure one thing, that the world where we live, we are all surrounded by different types of intellectual property, and we are all surrounded by different uh, types of intellectual property rights. Starting from, since you are all students reading, going for a movie, um, you watch in the phone, you have diverse applications you use in the phone. These are all just some of the many kinds of work which might be, which might have been protected under the different kinds of intellectual property protection. So that is why we must give our gratitude and thanks to the frequent appearances of the term intellectual property in the mainstream media as well as everyday conversation. It has by now familiar among the substantial segment of the general public. But however, as in the case of the parable of blind man or an elephant, we have different people. They perceive intellectual property very differently. So depending on their source, depending on their source of information, their day-to-day, you can say, interactions with the different types of intellectual property. Uh, for some, it is that branch, you can say, of law that protects technological innovation. And for others, it may be a branch of law that protects movies. It may be a branch of law that protects books. But many of them might find it difficult to define what is intellectual property. That is why part of the reason, as I told you, for the diverging perception on intellectual property and the difficulty that normally one faces in defining the term is the constant expansion being made of the subject matter, which is covered under, you can say, this area of law. So we must thank to the expansion of the subject matter over these years, and it has been increasingly difficult rather to find a common element in all types of, you can say, intellectual property. So that is why when we try to define, we always say that there is no single universally accepted definition for your intellectual property. So the fact remains that this is not surprising, because it is nearly possible to find one definition that can comprehensively cover all the subject matters that are currently considered. So that is why intellectual property will refer to creation of the mind. What are those creation of mind? Starting from your invention, through literary, through artistic work, through design, and through symbol, through names, apart from your images which are being used in commerce. So there are different way of looking at. So one way of looking at it is not a single homogeneous law, as I told you earlier. When we say that the term intellectual property refers to the loose cluster of legal doctrine that is going to regulate the uses of different sorts of ideas, different sorts of insignia. But however, if the term intellectual property will refer to a loose cluster of legal doctrine, then it becomes pertinent to ask when we can call among when we can call something as intellectual property. So that is why Bentley and Sherman rightly they talk about the intellectual, which indicates the character of some of the material this area of law protects. That means products of human mind being protected, products of intellect being protected, and the term property which indicates the form of regulation, and that means the grant of some kind of exclusive rights which operate, and that too in a specified manner, to manners which is quite similar to your rights over tangibles, because different countries, they have diverse creations of the mind under different branches of the law, starting from your patent law through your copyright, your trademark, your design, everything. So uh, uh, there is enormous necessity, there is rationale behind, there is justification for protecting intellectual property. Because while there are, as I told you, different theoretical background for affording the legal protections to different types of IP, obviously the most widely used one is the, as I told you, your incentive theory, that is your welfare theory. So in that case, one has to look for the patents. One has to look for the copyrights, um, and the patents. As I told you, that one has to be very sure that the we are talking of invention, and to invention, that too for the purpose of patent law, to be considered something as an invention for the purpose of your patent law. There are three requirements. So you need to meet the novelty requirement, you need to meet the inventive step requirement, you need to meet the industrial applications also. So in that case, you have to be very, very specific in case of novelty, because um, the any sort of invention or any sort of technology which has not been anticipated by publication in any document or used in any country or elsewhere in the world before the date of filing patent application with the complete specification. That means we are more concerned about the subject matter, and that too subject matter has not fallen in public domain. And the inventive step, that is a tough requirement, because that is a uh, kind of feature of an invention that involves the technical advance as compared to the existing knowledge, or having economic significance to both. That makes the invention non-obvious to a person skilled in the art. And it must be capable of industrial applications, which is a must. So it needs to be reminded that even if an applicant can show that the application meets all these requirements of patentability, but it would be worth to mention one thing, that to be successful in a patent application, it is also important to ensure that the subject matter of the inventive is not specifically excluded subject under the Indian Patent Act. So that must be ensured also. So copyright, similarly, which is protecting the creative work, which is protecting the artistic work. So you have certain right to defend your right, protect your right. And in India, since for a long time, the court, they followed the so-called the verdict. Uh, they normally go for that the collective management of rights is very common in case of copyright, and it is difficult to monitor as it is difficult to enforce rights at the individual level. And for this purpose, we have to see that the trademark is also another type of intellectual property rights, because in general, trademark will refer to the word, the symbol, or any other signifier that is going to distinguish the goods or services produced by one firm from the goods and services produced by another firm. So capable that something, a trademark as a mark, very much capable of being represented geographically, and which is capable of distinguishing the goods and services of one person from those of the other person, which may also include your shape of goods, your packaging, combination of colors, everything. And similarly, as I told you, that the geographical indications is also refer to the signs used on products that have specific geographical origin and the quality or the reputation of that product that is attributable to that geographical origin. So, in all these cases, we have to see that industrial design is also included as another type of IP, and which has garnered considerable prominence in the context of high-profile litigations like Apple versus Samsung. That was a saga where questions were addressed by the court whether Apple was entitled to prevent competitors from using the rectangular shape with rounded corners or round home buttons at the bottom of the screen on their phones. So all these things also will call for the plant variety protections, because there has been enormous demands rather which has come from diverse stakeholders for protecting the new plant varieties. So different countries have taken different steps for protecting new plant varieties, and India as a signatory to the TRIPS also is very much covered in that. So different categories in which plant variety can be registered in India. They are new variety, they can be registered under, or extant variety, they can be registered, or they can be registered under essentially derived variety. But we have to see that the something novel has to be there, essentially derived variety, and the extant variety, and non-obviousness, and industrial applications, everything has to be there. So in the case of trees, vines, the initial registration confers 9 years protection from the date of registration, and it is renewable subject to the condition that the total duration of protection cannot exceed your 18 years from the date of grant of registrations. So there has been also the protection of layout designs of the integrated circuits. So as one will notice one thing from the discussion which I made for the last for the last roughly 60 minutes to an hour, there are different kinds of intellectual property rights, and they play a major role in determining the access to knowledge, determining the access to resources today. So the significance of different kinds of intellectual property rights may only increase as we make a shift more and more to a knowledge-based economy. So in that case, more of taking protection and more of granting protection and more of enjoyment of your creation is required. And with this, we come to an end of today's session. Thank you very much. Have a nice time. Good day.